Okay, this panel is on juries as political actors. We have here, speaking first, Professor William Nelson. Professor Nelson is the Judge Edward Weinfeld Professor of Law at the New York University School of Law. He's been one of our nation's leading legal historians for a few decades now. Since the beginning of his career and continuing until today, one of his main areas has been the history of the common law in colonial America. So when we have these discussions about what kinds of cases juries decided in the common law at the time of the founding and before, we have here probably the leading person in the country to address those kinds of issues. So now to talk about some of these issues, Professor Nelson.
But I'm not going to do any of that today. I'm going to very briefly dissent from what I think has been an undercurrent of the early papers, then summarize the first 4 pages of what I've got here in one line in an effort to get over it quickly. And then I'm going to read the rest, again, to get over it quickly so that we've got some time left for discussion. So the dissent, judges like juries. I think judges always have liked juries. I think they like them now. Business never has liked juries. I don't think business likes juries now. Legislatures and juries have a lot of conflict between them, and legislatures oftentimes try to control juries. But judges like juries. As one Maryland court put it in the 1680s, it is useful for judges to give tough questions to juries, since litigants will understand that adverse judgments were not, quote, the judge's fault, for it was done by a jury. The other reason judges like juries is that she who does the work has power, but she who has power has to do the work. I will never forget sitting as a law clerk in a bench trial, having to justify the judge's findings of fact on the basis of a 3,000-page record. Why the litigants hadn't demanded a jury then was something that for weeks we could not forgive the litigants for not demanding a jury trial. So judges like juries. The point I want to talk about is not, I think judges have always tried to give politically tough cases to juries when they can. I think they do it now when they can. The point I want to talk about, I don't really disagree with the main thrust of what we've been talking about all afternoon. The civil jury is in trouble. I think the criminal jury is in trouble. Jury trial generally is in trouble. That is, I think, inconsistent with the framers' conception of what our government ought to be, and I think we ought to be concerned and worried about it. What I want to do is introduce what I think is a new way, an increasing new way in which the jury system is in trouble that no one hasn't talked about yet. And I want to talk about it by focusing on 2 particular cases. The first case is a 1761 case, Irving against Craddock. It's a Massachusetts case. The case arose, I've written about this, I wrote about this for the first time close to 40 years ago. I keep writing about it because it's such a fascinating case. The case arose when a customs collector enforcing the Navigation Act seizes a Boston ship owner's vessel for smuggling, takes the vessel to the local Vice Admiralty Court, which of course sits without a jury. The Vice Admiralty Court condemns it, and the customs collector then sells it. The total value of the ship and the cargo is about 1,500 pounds, which is a lot of money in 1761. Once the Admiralty Court has ruled, the ship has been sold and all, at that point, the merchant who owns the vessel brings a common law trespass action in the ordinary common law courts, brings a common law trespass action against the customs collector for unlawfully Viet armies with force and arms seizing his vessel. And I won't tell you about the lower court. It's a complicated case. But the case eventually goes up to the Massachusetts Superior Court. The Superior Court, all 5 judges unanimously instruct the jury that the admiralty decree is res judicata and that the jury must return a verdict for the defendant. The jury promptly ignores its instructions and returns a verdict for the plaintiff. The interesting thing is that the jury returns a verdict not for roughly 1,500 pounds, what the vessel and the cargo were worth, but for 499 pounds. I assume no one in this room has a clue as to why the jury rendered that verdict.
Well, we read your paper.
Oh, okay. All right. So you have a clue. What a, this is a 4 o'clock class on a Friday afternoon. The next thing, can you give me a clue the next time I teach a 4 o'clock class on a Friday afternoon to get that good a response from the students? Yeah. So the answer is that the Massachusetts Charter provides that if a case is worth 500 pounds or more, it can be appealed to the Privy Council, which of course will reverse what the court has done. And these jurors know the law, they know the facts, they're smart, they're politically savvy, so they return a verdict for 499 pounds. That is exactly what the Democratic community acting through its Democratic jury would have wanted. The next case is this case, State against May in Arizona, and now I'm going to start to read. State against May in Arizona in 2006. It's a prosecution of Stephen May, who was 35 years old at the time, for sexually molesting 4 children, 7 counts of molestation. The precise conduct is that May is accused of touching the clothing of the children in the vicinity of their genitals. There is no actually hand-to-body contact. It's all just they're dressed in one form or another, and he's touching the clothing. He was playing with 3 of the children at the swimming pool at the time of the touching. The 4th touching was of a child in a classroom where he's employed as a teacher's aide. The defense is that the touchings that occurred were accidental and not sexually motivated. I won't go through the details of my consultation on this case that I thought I had to disclose. I'll go on and say the jurors were troubled by the case. They're troubled by the evidence. They consider the case for a day and a half. They report to the judge they can't reach a verdict. The judge, with the usual Allen instructions, sends them back out. On the 3rd day, they report again they cannot reach a verdict, quote, because the not guilty side doesn't believe there is enough evidence and the guilty side believes there is. The judge then dismisses them, but somehow magically within the hour, the jury shows back up. They want to continue considering the case. The parties consent to their continuing to consider the case. The jury goes out again, and 5 hours later, it returns a compromise verdict, finding the defendant guilty on 5 of the 7 counts. The defendant is then sentenced to 15 years, which is the minimum mandatory term on each count. But the sentences have to run consecutively under the statute, so he ends up getting a 75-year jail sentence. I just want to focus on one little aspect of the case. A couple of you have already asked me, well, what happened during that hour interval after the jury is dismissed? The answer is we don't know what happened during that interval, or at least I don't know what happened during that interval. I don't know why the jury wanted to come back and continue deliberating. And I don't really care. There may be some profound error there. I don't know. I want to focus just on this one point. So why did the jury compromise? And the answer, I think, goes to a statement that the foreman of the jury makes once they go back into the jury room. And the foreman says, if we don't find him guilty on everything, if we just compromise, he'll just get a, quote, slap on the wrist. More specifically, he'll probably get only a year or two in jail. Several jurors have given an affidavit saying these statements were, quote, the biggest thing they, those who favored conviction, used to convince the jurors favoring acquittal to agree to a compromise. One juror continues to insist today that she would have never voted to convict on anything if she knew that the minimum mandatory term was 15 years. Now, what I want to say is that I think there is something, I'm not really troubled by juries compromising. Professor Lieb and I were just having a conversation before this began up at the podium about the difference between juries compromising if they're juries that sit in 2 weeks over a whole range of cases and they compromise by giving this juror his case and that juror her case. That kind of compromise maybe is troublesome. I'm not troubled by juries in a case where the evidence is just ambiguous, saying, we kind of can all agree he's not guilty beyond a reasonable doubt for 75 years, but he may be guilty of something, so let's give him the slap on the wrist, or even let's give him 10 years. I don't mind jurors compromising. The problem I have with this case, which I think is a persistent problem throughout the criminal justice system, is jurors compromising behind the veil of ignorance as to sentence, with the result that the compromises are leading to results totally inconsistent with the compromise that the jurors think they are making. And the case I've picked here, I think, is just a really quite extreme example of that, where the jurors, I think, did think they were giving this guy who, maybe deserves something, maybe doesn't, giving him a year or two, and instead they're putting him in jail for the rest of his life. And it seems to me that there is something fundamentally wrong with that. Now, at this point, I'm sure you probably think I'm sort of nuts. And what I want to do is defend my position on the basis of a particular conception of democracy. It's a conception of democracy that I find, and I hope you'll find, is attractive, though it is somewhat naive and clearly somewhat impractical. And that then leads me to compromise in what I'm suggesting ought to be done. My conception of democracy is not majoritarian, and that's the first thing I have to stress. I see no reason why an official who gets elected by one vote more than half should be permitted, should think that she has a mandate to enact policies that are anathema to those who voted against her. Legitimacy does not flow from exploiting transient technical advantages to obtain office. If you need to hear a name that I identify as the bad guy, the name is Karl Rove. And what I have against Karl Rove is not that he got George Bush elected, not that I disagree with his policies. What I have against Karl Rove is that I deeply disagree with his conception of what a democratic government ought to be about. For me, a democratic government is a government that tries to adopt widely supported policies that advance the well-being of the governed community as a whole. It's very much, I'm not being an originalist here, but it's very much a framer's conception of democracy, a pre-party conception of democracy. Now, of course, one has to face the reality that the community is divided And what are we going to do with that divided community? And sometimes there was a woman sitting right next to where Suja is now. I don't see where she's sitting now, that asked a question and said, well, isn't the reference to the common law in the Seventh Amendment about just simply passing the buck and we'll decide it in the future? And that's a form that I think compromise often takes in democratic bodies. Here I want to come back to this idea of the jury as the last resort. The jury is the last resort that can't make the compromise that way by passing the buck, unless they're simply going to have a retrial. They can't pass the buck. They've got to reach the decision. And I think it's a good thing for a democratic jury to reach a decision by compromise, by saying, okay, one side wants to give him 75 years, one side wants to declare he's innocent, we'll give him something in between, whatever they can agree on. But the important thing, I have to do a Marco Rubio now. We should elect him president because he may have been getting this damn bug I've had for a week, and you got to drink with it. We want juries to be engaged in compromise because we want compromise to be part of the democratic process. We don't understand that judges should be engaged in compromise. We're perfectly happy to have legislatures do it, but they won't, and there are all sorts of reasons why we understand why they can't. But juries can engage in compromise. Juries have for centuries engaged in compromise. We want them to continue doing it, and we want them to continue doing it because compromise is an important part of a democratic process. And we want it to be done by people who are responsible to the community, which jurors are, and impartial, which jurors are in the sense that they are randomly drawn and represent a cross-section. But we need them to do it when they know all the facts, when some of the facts are hidden from them. That means that they are not engaged in a compromise that relates back to the community. They're doing something else. They are making a judgment that has been skewed by whoever is withholding the facts from them, typically the legislature. And that no longer represents a legitimate democratic compromise. Instead, it represents some sort of political judgment made by an entity, a legislature typically, that is playing games with its, one vote mandate, where it is saying, we're not going to let people know what the sentences that will be imposed are. Because if they knew, we know they wouldn't do what we want them to do. So what we're going to do is impose sentences that are strict, but we're not going to let it be thought that these sentences will ever actually be carried out on real people. That will say is something that juries can do when it comes to carrying out sentences, except we're really not going to let them do it because we're not going to let them have the knowledge of what the sentences are. There's something roundabout and corrupt in this process of hiding facts from juries and not letting juries decide things on the basis of full knowledge of the facts. Let me just make some concessions now. I said, I hope you'll find this notion of democracy attractive, but it is somewhat impractical and naive. We're not going to go back to the 18th century view of cases like Irving against Craddock, where juries do, in fact, have all knowledge at all times. Juries aren't as well educated. Cases are more complex. There are good reasons at times to not give juries knowledge of the facts. business cannot. I mean, this is an argument I make in Americanization of the Common Law 35 years ago. Juries cannot. Businesses cannot plan, cannot engage in transactional planning on the case, in the face of random jury verdicts where they can't predict what juries are going to do. And sometimes you have to take cases away from juries so that business can predict. There are times when juries, as representatives of the community, will be deeply biased. Like if you give certain evidence, let them have certain evidence about prior criminal record, they may be very biased. So there are times when there'll be reasons why juries should not be given full possession of information. I just want to say two things. One, I don't think increasing the percentage of prosecutions that prosecutors will win is a good reason for not giving information to juries, number one. More than that, I think there ought to be a presumption against it. Whenever someone proposes, whether it be a court or a jury, a court or a legislature, that certain information should be withheld from juries, there should be a high burden of justification on them before they go forward. So what I think I'm really proposing as we think about the democratic role of juries, on the whole, we think voters, people who engage in the democratic process, ought to be informed about what they're doing. That seems to me generally to be a sound principle, that they ought to be informed. They ought to be knowledgeable about what it is that they're doing. And if that's true about voters, it ought to be true about jurors as well. So as a general principle, we want juries to be informed. A great deal of injustice can result if they reach decisions where they are not informed. But there are times when they can't be fully informed. For all sorts of reasons, maybe they can't be fully informed. And so it's okay at times to not give juries full information, to withhold some things from them, but there ought to be a demand for a high justification before that is done. Let's think about it and rethink some of the cases where in recent decades it has been done. And also, I think, to fit in with what others have said before, I think what I'm trying to do, now that I've heard the first four papers, I think what I'm trying to do is say there is another piece of the puzzle in which juries are being disempowered that needs to be considered along with some of the other pieces that others of you are raising.
Okay, thank you, Professor Nelson. Talking about conceptions of the jury's role in the democracy, and so appropriate we turn now to Professor Ethan Lieb, Professor of Law at Fordham Law School. He's written on a number of topics, most germane here in political and legal theory. He's one of the country's leading scholars on deliberative democracy, and more recently doing work on how to conceive of public representatives or people exercising state authority as fiduciaries, a concept imported from private law. Professor Lieb.
Well, thank you for having me. When we started, I was listening to my old teacher, Akil Amar, and I thought, oh, I have really come nowhere. I'm still sitting in the room listening to Akil Amar. But it's a joy, and then, yeah. But then I thought, wow, like that was my law school experience. I got to listen to that for hours and hours a week, and it's a really great memory. Then he got to the end, and he started citing me and quoting me, and I thought, well, actually, maybe I've come somewhere after all. Made him proud a little bit. Again, thank you for having me. I think what I'll do is begin with just telling you a little bit about a larger project that I've been working on, and then try to explain how the jury fits into it. To some extent, you might have heard your professors teaching against their case books, and I thought maybe I would come and actually give a talk against my paper, because I'm not actually fully convinced of it. But actually then I heard Akil use to describe something he was talking about as, actually, this is not outlandish. But so if that's the standard, I don't think what I'm saying is outlandish, but I am ambivalent about it. But with that, I still will try to convince you of it, and then you can tell me why I'm wrong, and maybe I will back down. So the background here is that I have been working on a series of papers, and I'm not the only one. In fact, you just hired somebody doing this, Evan Criddle, who's doing really excellent work in this area. And the core idea is to try to understand state authority as a set of relationships of discretion, trust, and vulnerability between ruler and ruled. And as Jason said, a lot of the idea here is to draw from principles of private law. You may have been exposed to these ideas in your corporate law classes. Fiduciary law is designed principally to promote trust and police certain kinds of betrayal and self-dealing in a set of special relationships that are susceptible to abuse of a certain kind, having to do with discretionary power in the hands of one, and over the interests and resources of another. The fiduciary is the one that has the power, the beneficiary, the one subject to the vulnerability. And this is not my idea. This idea has roots in Cicero and Locke. The American framers clearly talked about it. But it hasn't been given, I think, due respect among public lawyers to understand that each public office is a kind of public trust. Core idea is to use the tripartite indicia of fiduciary relationships to pick out state-subject relationships that need to be guided by and analyzed through the lens of fiduciary law. I actually think the vision that it leads to is a democracy that's not that dissimilar from what you heard Bill Nelson talking about. It just has a little bit more political theory fanciness. Okay. You can't, though, and this is some of the errors of the recent work in this regard, you can't just take principles of private law and say judges ought to enforce these against public officials. There's just an article published in the Harvard Law Review trying to do just that. I wrote a response saying, no, you can't. It's not that simple. This is an analogy. It's a work of metaphor, and it requires translation. And it's not that easy to do, and it's part of what I've been struggling with. In particular, you want to establish sui generis public fiduciary duties. You want to try to explain carefully who is the fiduciary in all of this. Is it the legislature as a whole, as an entity, as a body? Is it each individual legislator? Are judges fiduciaries in some ways? An article I'm working on that'll be out in a few months. Okay, and then you have to ask who are the beneficiaries? Right? Well, because one could imagine the beneficiaries are not just say you're a Republican representative, your Republican constituents, going back to what Bill Nelson introduced us to. We wouldn't think the Republican legislator is supposed to just pursue the interests of his or her Republican constituents. Okay, well, maybe the individual is supposed to pursue both majority and minoritarian interests. That's what it means to pursue the public interest when you're voting in a legislature. Might have different ideas about perhaps this was Jeff Abramson's question of Akil earlier. You might have a different idea about what the voter is supposed to do, but surely we think legislators, when they're representing, have duties of representation that require them to take account of minoritarian interests. But one could ask, how far does that, let's call it a fiduciary obligation, extend? Does it just say to the people of the state, when a state legislator in Pennsylvania is voting on a voter ID law, do they have to think about the implications of that decision for the nation at large? If Pennsylvania goes the other way, do we have a different president? Is it the obligation of a state legislature in Pennsylvania to think about national repercussions? Is that what it means to care about the people? If you take an oath to defend not just your state constitution, but your federal constitution as well, what kind of obligations do you have as a representative? Okay, so that's the background. When asked to come here and talk about the jury, I thought, well, I've done a lot of work on this stuff about public fiduciaries. Is there any way I can repurpose it and meet my deadline for the William and Mary Law Review? And the answer was, I think I have something, but again, I'm not 100% sure it quite works. Okay, the jury's a political institution. The people who serve in it are representatives. Constitutional law treats the jury as a kind of state actor, Okay? Voters are not state actors. If you vote for racist reasons, you are not in violation of equal protection, notwithstanding an argument Chris Elmendorf makes in the Penn Law Review recently. For the most part, our constitutional law treats juries as state actors in a way they do not treat voters as state actors. Okay? And one could say they're representatives not only in a descriptive way, but in a normative way too. So what does it mean to be a representative in a normative way? Something I need to unpack. Well, I've already unpacked this elsewhere, and so I'm applying the duties of representation that I've developed in this idea of fiduciary representation into the context of the jury. One would have to ask, though, can juries actually be identified by the criteria I highlighted before? Discretion, trust, vulnerability. Do these categories make sense when we think of what the jury is doing? And I think the answer is yes. And I try to make that out in the paper. Juries have wide discretionary power in several senses. It's hard to overturn their decisions. They operate in interstitial areas of law and interpretation. That suggests they have a kind of discretion. They have a special discretion in certain kinds of civil cases because the legally operative terms are normatively loaded. The discretion to tell the state whether punishment is authorized, whether a penalty can be exacted, whether the state may take property are clearly areas of practical and legal interest of another. Okay, one of the hallmarks of fiduciary power. From the perspective of trust, we do see a fair bit of trust. There's a debate about whether the people in general trust jury power, but it seems that they actually, even if they psychologically have some mistrust, they are in a situation where they can't help but trust them. We know monitoring is quite difficult because we don't know what's going on that well in the jury box. That requires a certain degree of trust. And then vulnerability extends not just to litigants who are obviously vulnerable to the particular jury in front of them, but those of us that are not litigants in a case are still subject to jury authority. If a jury decides to acquit somebody who is guilty, they run amok in our community, right? If the jury decides to incarcerate, we pay for that incarceration. Okay, so we are all, as a society, vulnerable to decisions, both action and inaction, that juries take. Okay. So I think this basically works. I mean, one can contest it. I'm not 100% sold on my own idea, but I think it more or less works. The problem, one problem I've identified is trying to exactly map, as I started with before, who is the fiduciary and who is the beneficiary. In some abstract way, I can convince you of this. But then when I get down to the nitty-gritty, who is the fiduciary? Is it the jury system as a whole? Is it each petit jury? Each panel? Is it each individual juror? And the paper tries to make the argument that it's actually both the jury as a body, say board of directors, in the corporate parallel, as well as each individual juror, right? So you can actually have both. When you sue for a breach of the duty of care in a corporate law context, you are suing for the board's failure to abide its fiduciary obligation. Okay? So you could think of the board as a whole, just as you could think of the panel as a whole, as being subject to a certain kind of fiduciary obligation. So too, when you sue on duty of loyalty, you're usually suing because an individual director is conflicted in a particular transaction. So too, each individual juror has a fiduciary obligation. So much for the question of who's your fiduciary. I'm working on an article called Who's Your Fiduciary? Who's the beneficiary? This is quite difficult to figure out. Here's what I write. Again, don't know if it's right. The most plausible candidate for the beneficiary seems to be the people themselves. This understanding reinforces the jury's traditional role as a counterweight to legislative and common law power in elites and rulers, as well as the idea that the jury stands in for the community and the community's norms. It also facilitates a way to see the jury as standing in a relationship of political representation with the polity's membership, whose laws are being enforced and tested in a given litigation. This way of identifying the beneficiary respects the relational dimension of political representation and confirms the jury's channeling of the people into the legal system, enabling the people to represent themselves in the application of law to individuals. Admittedly, this identification of the beneficiary begs questions about how broadly to delineate the people. Is it the people of the district, the people of the region, the people of the state, the people of the nation. But I think this is just the sort of question representatives ought to be asking themselves in any given context or trial. This is controversial. I think some people would say something like, I think the litigants are the obvious beneficiaries. Or in a criminal case, it's the defendant who should clearly be the beneficiary. I don't think that's quite right for reasons I specify in the paper, but we could talk a little bit more about it in Q&A. I want to leave some time for Q&A, so I don't want to belabor the point. I'll say a couple of things by way of conclusion. To say we're fiduciary representatives when we are serving in the jury, both as a panel and as individual juror members, doesn't actually tell us how to enforce fiduciary obligation. In the corporate context, we invalidate transactions, right? We use moral rhetoric to describe how inappropriately somebody behaved, and we're doing it within a courtroom context. We're having a judge apply fiduciary law, and that is not really available to us in quite the same way. So what do the ultimate duties amount to? And the rest of the paper tries to cash that out. And I'm not sure that the theory has a point unless it can cash out something for you that you actually want to know. I think this is a meta-theoretical point. There's a reason why we build theories, and it's to both fit and justify the practices as we have them. And I think the fiduciary political theory does a pretty good job both fitting and justifying the kind of jury system that we have. But it does help you take a position on certain matters as well. So if you think the duty of loyalty is to the people, this actually provides some justification for the practice of jury nullification, which you need a theory to explain why it's okay for a jury to disregard the law. And I think the fiduciary theory, where the proper beneficiary is the people, the community's norms, provides that kind of justification. It takes a stand. So Jeff Abramson's important book on the jury sets up two possible ways you can think about the jury. You could think about it as a bunch of people with different interests coming into a room and representing their own interests as they debate freely. Right? The fiduciary theory says, no, we're going with a different model. The model is you represent the community. That's if you bring your personal partial interests into the jury room, you are violating your duty of loyalty, your duty of faithfulness to the community. Okay. I think I'll stop there. I think I've given you enough to chew on. The basic idea, again, is applying a more general project that is trying to introduce you to the architecture of power relationships of discretion, trust, and vulnerability, and scaffolding them with these special moral and ethical guidelines for the careful and loyal exercise of state authority. Thanks.
Great. Questions? Comments? Yeah, Professor Abraham.
My question's going to go to Ethan, but I just made it to Professor Nelson. I just want to say that though I've learned a great deal from every presenter in this room, in my mind, the whole private place. I want to make sure I'm getting something right. I know about a fiduciary relationship. But I can trust that it's in your book, you've done your archival work. So, I just wanted to say that.
Thank you. I want this 4 o'clock class every week.
So, I'm largely sympathetic, but I want to run through some issues. First, just on the positive side, I read you mentioned law. I think in revisions, I think we ought to make more use of law, because law is the premier appeals to those civil society reformers on the basis of social contract. The relation of government to civil society is a fiduciary relation. And I think if you look at what happens in law, or you have that people do not have rights against society, you can play out the pros and cons of what they're trying to do. It would be a really good source to try to do.
Can I say one thing just about that? I think that there's a great tension in Locke between, on the one hand, a social contract theory, and on the other, a fiduciary theory. What I'm so attracted to about what I'm calling fiduciary political theory is precisely that it gets you out of the tacit consent problem. What it tells you is you are finding yourself within quasi-voluntary relationships of power. And that constrains what it is that government can do. Once government holds that public trust, it is disabled from doing a variety of things in your name. And so in other words, I do try to play up the way in which this is actually one could call it a complement, or one could call it an alternative in a way to social contract theory. So I'm very attracted to it for that reason. But Locke is obviously also conventionally a social contract theorist, and so it requires a fair bit of reframing. Yeah.
Right, well,
No, finish. Go ahead.
well, I made a list of questions I wanted to ask you, so I'm just going to just run through them. If it's
We
okay.
can also do this at dinner too. We're having dinner together. Yeah.
That's the point of the
Yeah.
conference.
Public. Yeah.
Well, because you had a dialogue with yourself, you had a little internal rumination with yourself during the presentation, so I'm
It's
just.
charming, right?
Fiduciary relationships. One, it's an odd fiduciary relationship. It's an odd fiduciary relationship because the fiduciary can't communicate with the beneficiary. And that's a conversation between you and Jason. That Jason is important about the derivative model that there's no public reasoning going on. But in most fiduciary relationships, there will be some communication and some ability to communicate. This is distinctive. It doesn't look like a fiduciary relationship. Two, can't do due diligence. Sherry Diamond et al. Came about embedded experts is another conversation that should take place because there's a restriction on what due diligence would mean for this fiduciary. Third, your point, it's hard to know why the fiduciary relationship goes to the people, why you come out there rather than to the legislature. And this is a conversation between you and Bill Nelson. In the case he's describing, should it, is the jury there to enforce what the legislative will was on the penalty? Is there some other independent fiduciary duty? But that's a deep problem to disentangle those. Third, it must make a difference that there's in some circumstances, it's not about the jury, but in general, where you want to go with the public jury. That election must make some difference. I mean, delegation of authority of an agency is one thing, but when what you're calling a fiduciary, like the independent status of an election, there's a source of authority there that doesn't flow. And at least the way I understand agency law, from the principle, it flows the beneficiary and the principal they can be in two different corners.
Sixth or seventh.
I'm just going to maybe to this.
Okay.
This is just use fancy word phenomenologically. I just think that the moral psychology of Jews has to be different. Their self-understanding has to be different than an agent's is. And that's precisely because if they are a fiduciary, if they are the agent, they're also the principal. I mean, they are the agent, but they also are the principal. And to me, it'd be hard for me to understand them seeing themselves as standing in the way an agent does to do the will of the principal, what's in the best interest of the board. They are there to debate, but in their judgment is, I can't finish the thought, but it doesn't strike me as wholly like fiduciary relationship. On the other hand, I think what you do capture is this notion that we are looking for a political theory that explains the remarkable lack of accountability, public accountability. We need something to sort of put in there. And so I'm sympathetic that if you continue to do this, you answer those questions, I think there is a good problem.
Would you like me to take the last part
Yeah.
first? Or?
John.
No, we'll have a beer. How about that?
Ethan, a couple of points on your thing. On agency, it strikes me that the fundamental law appoints jurors as agents. That's what the Constitution does. And it says, to my mind, what it does is appoint them as agents for the people as a whole to make decisions that we would not entrust to elected representatives. That's one way to look at it. That's the only way, obviously. But I think one tension that I but then you also say that this is jury or duty to the legislature to apply the law. So I think one question that you don't answer is, what is the role of the jury? Is it a law-making body or is it a law-applying body? And I think that's a tension that I heard in your speech. And for both of you, since you're talking about juries as political actors, I could feel this came up in your talk when you talked about hiding things from the jury. And I'd like both of you to react. In a typical, many states have statutes that limit non-economic damages that can be awarded to the jury. But generally, they require the jury not be instructed that that cap exists. You have situations, for example, one I can use one to describe it, where a jury deliberated for 4 days on the amount of non-economic damages. The amount they started at was above the cap. And when they were subsequent to their verdict being rendered or the judgment being entered on it, they were informed by a reporter that their verdict was reduced. And they were livid about having spent 4 days of their time for no point at all. And I'm interested in any reaction.
I'm ill. I said I'm ill. I agree with them. I mean, I don't see why information like that should be withheld from a jury. But I guess, I hadn't been thinking about juries as fiduciaries. I'm clearly seeing juries as agents of the community rather than as agents of the legislature.
Yeah, I mean, so I think I agree with that. One of the challenges of a previous effort in this regard was thinking about how judges have to behave, and so from some perspective, judges are supposed to be representing the people, but much more commonly in exercises of statutory interpretation, we say quite conventionally that the judiciary is an agent of the legislature. And so that is much more common as a phenomenon within the judiciary, and it places the judiciary in a very complex scenario with multiple kinds of beneficiaries. As to the question of agency, I just want to, I guess, respond by way of saying both agents and trustees are fiduciaries. So even if your view is that the individual juror is directed in an agency fashion, you can still call that individual a fiduciary. So too, if your view is they are a trustee of a certain kind, you could say they are also a fiduciary. And fiduciary law doesn't apply in a completely univocal way that supervenes completely. We say the duty of loyalty and the duty of care supervene, but how they're actually applied on the ground vary substantially, depending on the kind of fiduciary you are. So it's actually a theory that has a lot of flexibility. It may have too much flexibility, and that's why I'm growing more ambivalent as I apply it in more cases and say, is this framework doing enough? Or is it just another area where you're making cost-benefit analysis and not really, the terms are just so lofty that they're not doing enough work. But in the jury context, I do feel like it's accomplishing something. There is the transparency problem that Jeff was talking about, the accountability problem, but I suspect that highlights a need for reform in this area. So Akil was talking about an ombudsperson, and at the back end of the paper, I think of the ombudsperson not as an ombudsperson who's fighting for jury rights, but as an ombudsperson who is helping what I call deliberative engagement between what the jury is doing and society. So there is some accountability. The accountability is if people don't like what juries are doing, they tell their legislators to write better laws and more careful laws and constrain jury discretion. So there is a feedback loop going on. It's very indirect form of accountability, but that doesn't mean there isn't any. In the guardian-ward context, another conventionally fiduciary relationship or parent-child relationship, the kind of deliberative back and forth between the fiduciary and the beneficiary is attenuated. And so it's not clear to me that you're just out of the category if you're not communicating particularly well. There are these oddities about the jury where the more ignorant you are, the better. If you know nothing about the intersection where the accident occurred, you're a better juror. That's weird in some sense. But must we have to make more sense of that?
You push that point. It's interesting. And all three of you have come to the same conclusion on that point.
Just to add one other quick thing, one reason, of course, why you might not tell the jury about the damages cap is because then they might act on behalf of the community and figure out a way around it, right? So they might say, we're representing the community, and so we're going to up economic damages, right, to get around the non-economic damages. And then, of course, the legislature could say, we were elected, right, to your point about don't elections have to play some role. We were elected representing the community. We passed the damages cap. And so I think the question of who represents the community, does come into play here. Yeah, Greg.
I want to give perspective from a judge. I might be the only trial judge in here. If there is another or more, I'd like to hear his or her comment. But listening to this, I feel like I've gone into the ethereal and, very metaphysical.
We do our best.
But let me tell you, having presided over hundreds of jury trials, this fiduciary stuff is off the table. Even this concept of jury as political function. I know the Supreme Court used that term in Taylor versus Louisiana, and it bothered me then. I'm kind of bothered today because I tell the jury that you have to help me administer justice, and you have to render a fair and just verdict according to the law and the evidence. And that's where the rubber meets the road. And they have to be faithful to the law and to the evidence and the instructions that we judges give them. And jury as a political institution, we don't need politicians in the jury box. I mean, if politics, a political function is some kind of power game where my views should dominate or my tribe's views should dominate or my party's views should dominate. It doesn't belong there. This is a case. This is a case for controversy. We want to decide. We want to reach a fair result between these two disputes. And so I hate to throw water on this fire, but this really, I don't think, helps the administration of justice and the role of juries. To make juries more educated, do a better job, help courts do a better job. I'm not seeing where this discussion helps.
If you're saying to the jury that their job is to reach a fair and just result on the basis of the law and the evidence, aren't you introducing? You could just say to them, your job is to reach a result on the basis of the law and the evidence. And if that's unfair and unjust, or you think it is unfair and unjust, you should reach it anyway. Because your job is just to decide on the basis of the law and evidence. Once you introduce those ideas of justice and fairness, aren't you introducing something that at least some of us will understand is something political? They've got some obligation when you use those words. I think they've got some obligation to have reference to something in addition to simply the law and the evidence.
I take, it's always a breath of fresh air to hear reality. I won't call it a cold shower. But I take it we ask jurors to take oaths, and we ask them to take oaths because we ask them to take their job quite seriously. And it is, in part, academics' work to figure out what it means to take that job seriously. And it is nice that judges have views about what it means to take that job seriously. And of course, their experience day to day should be heeded. On the other hand, it is undoubtedly the case that part of the reason we have the jury there in the first place is to control certain kind of agency costs of other government actors who we don't actually trust. And I'm sure you're a great guy, but you might have been elected. And you might have been elected with campaign contributions from people I should be skeptical about. And so I don't know what's going on in your courtroom. And so I want to make sure, as part of my job as an educator, that each individual that walks into your courtroom that's going to be adjudicating cases has a fuller picture. of the job that they're supposed to do. It's why Andrew Ferguson's book is an effort not just to talk among scholars about what a jury is, but to actually instruct jurors day to day. Think about what your job is in a serious way. Don't just listen to what that guy in the black robe is saying, because we don't know exactly how he got there, and he's just the government, and you are the people. So I'm sorry I got polemical, but you know.
Now I also have to add that when I was when a voir dire was done on me on another occasion, and the judge, after all the questions had been asked any of us, do we have any other things that we think we ought to disclose? And I put my hand up and said, I attend conferences like this. He immediately threw me off the jury. And I fully understood then, and I fully understand now why. But I still think that, having said that, I think that jurors do have an obligation to do justice.
We'll take one more question. Steve.
I find myself in a useful position of following Jeff Abrams and agreeing with almost everything. First about Professor Nelson's work is just a phenomenal foundation for much that's come beyond it. And I wanted to just tell him that Terry Diamond's really a wonderful piece called Blindfolding the Jury, which consider these matters from a psychological perspective. I think it's a terrific, one of the most insightful analyses of jury problems. As the professor leaves, I love the idea, but like Jeff, you get hung up in the details, and I start thinking about the actual procedure, and at each turn I'm troubled by your ideas. For example, the Batson line says that citizens have a right to be jurors. Now, no one has a right to be a fiduciary. Now, when you start thinking about what it is that a juror is in that concept, the right to access and sit to be a part of the process, I think you start to run into difficulties with conceptualization. You say jurors are state actors. Well, they're only state actors that are removed, because what they do is they hand it to a judge. The judge, for example, is an appellate process. I'm not so sure that they really are state actors, except in some attenuated sense. The third piece, Professor Nelson mentioned voir dire. Well, we don't get the voir dire representatives that get to talk to us and so forth and so on. And then we have this striking process, sort of taking people off the jury. Again, this is not the same kind of process. I would be more comfortable if we really were better anchored in the steps that actually are taken to support or face the heat when great minds and others say, wait a minute, you're not getting it right. Okay, well, look at those.
Well, so in 60 years, maybe you'll all sit around and give me a love fest. But in the interim, I appreciate it. So as to the state actor issue, I think you're just wrong. So I think it's clear that juries, when they act and award something to a litigant, are doing so with the power of the state. So I think in that specific, you're wrong. You're absolutely right about that we have a right to serve, and no one necessarily has a right to be a fiduciary. But, it's kind of like saying not every aspect of the analogy holds up, of course. I want to explain core features of what the jury is doing and who they're protecting and what they ought to be thinking about when they're doing their work. It explains a lot about selection mechanisms. It doesn't tell us a lot about the right to serve, and that's true. But this is not meant to be a comprehensive theory that tells us everything we need to know about the jury. It's meant to illuminate a couple of important things about fidelity and impartiality. It helps us understand something about the decision rules. And if a theory can do all of that, but it can't get you everything, I'm satisfied. Political theorists don't have those kinds of ambitions. I think it was you who said after your talk, let's not try for the pie in the sky. So I'm not trying for the political theory that's going to solve all political theories. I don't expect to be the next John Rawls, but if I can move the conversation forward in small ways, I'm satisfied for the time being.
Okay, I think we got a lot to talk about, but let's take a 5-minute break and we'll come back for our final panel.